Part 3. Fundamental Rights. Article 12. State. Present Article 12 was introduced in the draft constitution as Article 7. Dr. B.R. Ambedkar, in the Constituent Assembly debates, said the object of fundamental rights is twofold. Firstly, that every citizen must be in a position to claim those rights. Secondly, they must be binding upon every authority. Subscribe the channel and hit the bell to not miss any update. Part 3 of the Constitution, from Article 12 to 35, deals with fundamental rights. These are the restrictions on the power of the legislature, executive, and the judiciary, that no one can violate these rights. Fundamental rights derived its inspiration from the Constitution of USA, where it is called as Bill of Rights. Fundamental rights are available only against the state, not against the private individuals. The actions of the agencies that fall within the term state can be challenged in the courts of law as violating the fundamental rights. In Maneka Gandhi versus Union of India, Supreme Court has held that the provisions of Part 3 should be given widest possible interpretation. Article 12. Definition. In this part, unless the context otherwise requires, the state includes the government and Parliament of India, and the government and the legislature of each of the states, and all local or other authorities within the territory of India or under the control of the Government of India. Article 12 has defined the term state for the purposes of Part 3. According to it, the state includes the following four categories of entities. Firstly, Government and Parliament of India, that is executive and legislative organ of the Union government. Secondly, Government and the legislature of states, that is the executive and legislative organs of the state government. Thirdly, all local authorities, and lastly, all other authorities. Dr. B.R. Ambedkar, in the Constituent Assembly, said, "I shall presently explain what the word authority means. Upon every authority which has got either the power to make laws or the power to have discretion vested in it." According to Oxford Dictionary, authority means a person or organization exerting control in a political or administrative sphere. Subsection 31 of Section 3 of the General Clauses Act defined local authorities. It includes authorities like municipalities, district boards, panchayats, improvement trusts, and mining settlement boards. The phrase all authorities is not clear in the Constitution. This gave birth to a series of judgments and cases to define state. In University of Madras versus Shantavai, the question before the court was whether university can be state within the term other authority. The Madras High Court held that other authorities could only indicate authorities of a like nature, that is, ejusdem generis. It means authorities exercising governmental or sovereign functions. It cannot include natural persons or juristic persons, such as a university, a state within the term other authorities, but only if an institution is maintained by the state, then it can be included within the term state. According to this judgment, universities are not state. In Ujjambai versus State of UP, the Supreme Court rejected the principle of ejusdem generis and ruled that there is no common genus or connection between the authorities mentioned in Article 12. In Electricity Board, Rajasthan versus Mohanlal, the Supreme Court formulated a new criteria for state. Supreme Court stated it is not necessary that the authorities must be performing governmental or sovereign functions. An authority created by the Constitution of India or under any act, and it has the power to make laws, and it performs functions very close to governmental or sovereign functions, is a state. According to this decision, universities are state within Article 12. In Sukhdev versus Bhagat Ram, question before the court was whether any institution created by a statute or act for commercial purpose can be regarded as state. In this regard, Supreme Court said statutory bodies such as ONGC, LIC, which are set up under special statute, are state within the expression other authorities. In Ajay Hasia versus Khalid Mujib, a constitutional bench of Supreme Court propounded the determining test for state. It said if a body or entity is acting as an agency or instrumentality of state, then that body or entity is a state within the expression other authority. By this, Supreme Court held that a society registered under the Societies Registration Act 1898 is an agency or instrumentality of the state and hence a state within the meaning of Article 12. Apart from it, here Supreme Court gave 6 criteria to determine whether a body is an agent or instrumentality of state. Firstly, if the entire share capital is held by the government, then it can reasonably say that the corporation is a state-controlled authority. Secondly, if the financial assistance of the state is so much that the expenditure of the corporation is covered by this assistance only, then it would mean that the entity is a state-controlled organization. Thirdly, if the corporation enjoys a state-conferred monopoly. Fourthly, if there is a deep and pervasive state control. Fifthly, if the functions performed by the corporation are of public importance or are related to governmental function. And lastly, transferring a government department to a corporation. Although, in the case of Pradeep Kumar Biswas versus Indian Institute of Chemical Biology, Supreme Court essentially overruled the Ajay Hasia case and held that there is no hard and fast rule that registered societies having link with the government are always state. In G Telefilms Limited versus Union of India, Supreme Court followed the Pradeep Kumar Biswas decision and ruled that though BCCI perform public function, it is not a state, whether judiciary is state. In Ratilal Panajan Gandhi versus State of Bombay, it was held that judiciary is not state for the purpose of Article 12. Although in A.R. Antule versus R.S. Nayak and N.S. Mirajkar versus State of Maharashtra, it has been held that when the judiciary is exercising rule-making power, it is state. But when it is exercising judicial power, judiciary is not state. Thank you so much for giving me your valuable time. If you have any doubts, do let me know and I'll try in the best possible way to clear those doubts. If you love the video, do like and subscribe the channel as I'll be posting regularly such law contents. Till then, I'm Ricky signing off.